support for Success Express, your business, career, and financial radio magazine. Hosted by Lisa and Nancy, editors of BigBlendMagazines.com.
So a new year always means there's new employment laws, and that means Ward Heinrichs is back here on Success Express, our Big Blend business radio show here with Nancy and I. And Ward Heinrichs is a San Diego employment attorney, and of course you've heard him on the shows for over the years, and he's also an editorial contributor to Big Blend Radio and TV magazine. And when it comes to hospitality and tourism news, he features stories in our Parks and Travel magazine. Good thing to do is go check out his website. It's bestemploymentattorneysandiego.com. You can also find him on Twitter and Facebook. He's always posting relevant information to keep everybody up to date. And of course, when there's new laws, that's really important. We always love it when he comes on at the beginning of the year to keep us up to date, because it's not that easy to find out what's going on and in regards to new laws. So welcome back, Ward. How are you doing?
I'm doing well, and I'm glad to be back right before Christmas. Let's talk about some new laws.
I know. Jingle jangle, behave at your Christmas party and your New Year's party.
Yeah.
Yeah, that's right. We didn't do one of those this year, but boy, yeah, you better behave. That's all I have to say.
Yeah, I know.
No sitting on Santa's lap.
No, you may not want to do that. I don't know. Here we go. Why don't we just go right to sexual harassment? We've talked about that over the years. That is something you said that there's some changes in regards to that for California.
Yeah, there are. Actually, the law that this new law addresses was passed last year and went into effect this year. And that essentially says that if you have 5 or more employees, and it used to be 50 or more, then you have to give sexual harassment training to your managers and this is new for everyone, to all the workers, all your employees. And so the employees need 1 hour of training every 2 years and within 6 months of becoming a new hire. So that's pretty big, but it was such a big move that the legislature decided to give everyone another year to comply. The old compliance date was January 1st of 2020, and they moved it back a year to January 1st of 2021.
Okay, wow. Okay. And then what about if you are, like a temp, especially like seasonal work and things like that, and not an independent contractor, we'll get into that too, but you come in for seasonal work, do you get training for that too?
You do. It's supposed to be done within 30 days or 100 hours of work. So it's certainly possible that a seasonal worker might work 100 hours before the 30-day deadline. If that happens, then it's supposed to be done by then, this training. However, if someone's short-term and doesn't work 30 days and doesn't work 100 hours, technically you don't have to give them training. So an employer has to look and make good estimates, and it's smart to make the good ones because you don't want to be on the other side of this law.
Yeah.
And give the training if appropriate.
Everyone also, Ward's article on this is up on blendradioandtv.com. You can read his other articles there. One of them really focuses on the new AB5 or the ABC test, where we get to learn our alphabet. No, it's really about finding out if you're an independent contractor or an employee, right? So this is something that really throughout 2019 kind of built up, and there's still lawsuits going on with Uber and Lyft, and still drama with this.
Oh, there certainly is, and there will be for a while. Just a little background. How many articles have I written on this? It's such a big thing, and
I know.
And they're posted on your website. They're posted on mine. But it all started about a year and a half ago with the Dynamics case, and the Supreme Court said, okay, we're going to adopt the ABC test. Now, the ABC test isn't new. About 2/3 of the state had some form of it or other, but California did not, had this complicated Borrello test. And then the legislature said, well, all right, Dynamics, that makes some sense, but it's limited in which laws it will apply to. So why don't we apply it to basically all the employment laws, and then also write in some ways to get out of it. Exemptions. So there certainly are certain segments of the economy that are protected from the ABC tests if you meet those exemption requirements. And so that's what the legislature said. We're going to make this applicable throughout, and we're also going to limit it in some ways. So that's what's happened. And if you do meet an exemption, that doesn't mean that all your workers are independent contractors automatically. It just means that you go back to the old, more complicated Borello test. And in some cases, there are a couple other tests that might apply to determine whether your workers are independent contractors or not.
Wow. So everyone, Ward's got a full article on this and also a radio segment that you can listen to. It's up on blendradioandtv.com and linked over from this article too, because you get involved in who's, part of it, who's not. And I just think, we're just in such a change of society. I mean, because people freelance all the time. I mean, Nancy, you were on a website the other day about it's a website just for freelancers, right? And people that
Right.
Yeah.
Yeah.
Oh, yeah. Well, I have been too. So I guess Nancy and I are doing the same thing. We're looking at those freelancer websites going, I wonder about this one.
Yeah, look at that.
Yeah.
Yeah, well, it's an interesting thing,
Mm-hmm.
I'm wondering even what happens with web developers who
Uh-oh, Nancy. Madam, I'm going to fire you and you can fire me.
yeah, I mean, because it's an odd business. If you develop a website and you host the website for a client, what happens? You work on it maybe once a month or whatever. Does that make you an employee?
Well, yeah, good question. And I think there's exemptions that could apply in that situation. It's going to depend on the specifics of the situation. Business to business comes to mind because they'll have more than one client, and if they hit all, they work their own hours. They're basically independent professionals. Then that's really possible. And I'm trying to remember if there's a specific one for web developers.
There was one for graphic design. I remember that.
There's graphic design. I don't know if that's a web developer though. I don't remember a specific one for web developers. The advertising, there's one there too. So that's possible, but
yeah, see that?
Yeah,
advertising. So kind of
right. It's possible, but I'd have to. You see, the law is so new, and it's really detailed in how the exemptions apply. And so, honestly, I just don't have most of that stuff memorized. I kind of remember, maybe it'll fit into this one, maybe it'll fit into this one, and to really make a better call on that, I have to look at the law, look at all the requirements, and then I can give you a better opinion.
Ward, do you still do it where people can call you and say, this is my situation, like you do like a free kind of estimate call, like to see if they have a situation? You know what I mean?
Well, absolutely. I do it for both employers and employees, because employees may be wondering, hey, should I be being paid as an employee? I should say workers and businesses. The worker may have a question as to whether they should be an employee or not. And business, where I'm getting most of my business on that right now is from businesses who are concerned about this.
Yeah.
And so, I give a free consultation, 15, 20 minutes, to get a feel for what's going on. And then if they think that it makes sense to move forward after that, then we sign some more formal contract.
Okay. It's interesting because, everybody does have a different situation under this ABC test. And, now the laws there do you think they're going to tweak the laws in any other way, or is this now like, that's it?
Yeah, great question. No. All right. So you mentioned Uber and Lyft. Uber, Lyft, DoorDash put in $90 million to get this on the ballot. Now, I don't know what the language of the referendum is going to be, but I'm assuming that they are trying to just exempt themselves. I don't think it's going to be a broader exemption. I might be wrong, but that's my hunch. So if they're going to get that on the back, I'm feel very confident if they put $90 million in, they're going to get enough signatures. I think they need like a couple million signatures. I haven't seen people collecting them. Usually I do at Home Depot and other places, but that's going to happen, and I assume they'll get it on the ballot. So when they do, then the people are going to vote and determine whether those three, and maybe a little broader category, who knows for sure, may have a new exemption.
Wow.
So yes, that's gonna be very interesting, and then I think the legislature is going to be continued to be petitioned by various segments of the economy, saying, "Hey, we want an exemption too." So I don't think that's over from the legislature's position either. I'm going to guess that in the next few years there'll be more exemptions added, probably.
Wow. Wow. Before we got on the call, we were talking about sexual harassment and, Survivor, the TV series. It's a reality show. So you have these survivors on there on this island. And one was a naughty nunu and was touchy. And the one girl's like, you can't touch me, and put in a complaint. And then everybody said, okay, they had a little, strict talking to on him. And then he stayed on the, on the show, and people didn't vote him out. I would have one lady went to kick him out. She's like, you can't do that to the girls. And everybody else turned on her, which sucked, but because he should have been kicked out. Then he got kicked out because he touched one of the staff, the crew, the film crew or somebody in there. And they made a big deal of it when, the winning event and everything. So Nancy, I wanted to know what happened with this guy. But it's interesting to me because when you think about these like these reality shows, I know they have to sign all kinds of things, but I wonder if contestants on shows and people on these reality shows, game shows or whatever, especially for the number of days, even though it's it's a contest, right? Doesn't that also almost get weird in regards to, are you an employee in some way because you've been there? So you know what I mean about those? Yeah. The two laws kind of.
But they're not paid. I don't think they're not paid.
But they're filming in Fiji, so you can get away with anything.
I was going to ask you that. Where are they filming it? Because that could have a big effect. And I'm going to guess that California law does not have a long arm that stretches into Fiji.
Unless they're a California company. If they're California based, it's Survivor. It's a TV.
But it's a game show. Even though it's a reality show, somebody at the end wins $1 million. So I don't think that the contestants aren't being paid to be there, so they're not employees.
Yeah.
That could be another issue, but under harassment's a little different than other types of discrimination. And I kind of lump it in under the broad umbrella of discrimination. All you need is one employee to qualify to be subject to the harassment laws in California. In all the other discrimination types of discrimination, you have to have at least 5 employees. So right away, it's different. Now, it's also different in this way. Independent contractors cannot be harassed either. So if you're a contractor and you come on the site of a business, they can actually file claims. It's possible. You don't see them very often, but it's definitely possible. And a business also has a duty to prevent third parties like independent contractors coming on their place of business and harassing employees. Now, of course, there has to be notice under that situation. So if the business didn't really know what was going on, then they're probably okay. They probably won't get sued, or the suit won't be very effective. But if they're on notice in any way, that's a big issue for them, and they have to take action under the law.
And on Survivor, they had to do it on TV. So now everybody knows, and this guy was a talent dude. He's like a talent rep or whatever. So he's probably touching all his talent.
I beg your pardon.
No pun intended.
That was well. Yeah. Hey, listen. Hey. Oh boy, here it is. It's a holiday season. We can be cheerful. But the thing is, that's on TV too. So this is people. Like for the girl that complained, this is now publicly speaking about it. And she's in the weird situation. So I wonder if they have a clause, like if someone touches you or, when you're signing all of that, saying that I'll go on this TV show and, You know how when they say you're going to go on an any kind of like you go horse riding, you have to sign like on a trail ride with the company. They make you sign like, okay, if you fall off and heck, it's it's not our fault. But meantime, they're still going to sue if that happens.
Well, and there's limits to that doctrine. You can protect yourself to some degree through contracts, but if the business is responsible for increasing the risk beyond what it normally is, and there's some cool cases about this in baseball, foul balls in baseball, then the business can still be on the hook for the injury. And so that's a little bit away from employment law, but I want to tell you this quick story. I forget where it was in California. I forget what minor league team it was, but there was a dinosaur that had a Nerf bat, and it was hitting some guy on the head with a Nerf bat when a foul ball was hit, and it hit the guy and he got injured. So under that circumstance, the waiver did not work. The guy got the sue because they increased the risk. So that kind of thing happens. That kind of thing happens, and that would largely determine whether someone's potentially liable or not.
Wow.
Now, what was interesting about the scenario you spun out was if that had happened in California, employees are kind of an issue, but with harassment, less of an issue because, like I said, independent contractors, there's a duty to keep independent contractors free from harassment as well. So. I don't know what category these people are in. Volunteers, maybe, and maybe not. But even then, there still could be liability. I don't remember if the statute says volunteers specifically, but it does talk about interns and other things. So, assuming it's that broad, then the harassment if that had happened in California, that could really be a problem. And the business could be on the hook for that. Now, I don't want to get into too many details and analyze it too specifically, but there could be some defenses there too that pop into my mind. But also, there's risk. There's risk in that kind of thing in California for sure. Now, Fiji, I don't know. They could have opted into having California law apply. I'm assuming that the filming company was a California company, and maybe they go, you know what, we're going to Fiji, but shoot, we're going to protect you under California law. Well, then it probably would be. So kind of interesting.
Yeah, I know. Now I'm like, I want to follow this up now on Survivor. I want to call them up and say, give me the details. You never know what we're going to talk about on these shows. It's really interesting to me about this. So when you sent your article in, the first thing that popped into my head, well, not in my head, that I saw was lactation. And okay, so now I'm not going to be a school child and giggle, but I feel like it. I couldn't believe it. I had to do a double take. I'm like, what is that? Like, is that's a weird law? And then, so.
No, it's big. It's a big issue.
Okay.
That's why I included it.
Don't make
That's why I wrote about it.
But is this part of also like I know that a lot of companies are making some changes and movements for even having like, a little school, like a little play area for kids, like so for moms that are nursing or are going back to work, they have like daycare in the building, like Google does stuff like that, these big corporations.
Right. Yeah.
So
I think you're right. I think you've hit the nail on the head. It's part of a societal movement. So this law fits within that movement. I mean, you might even question whether the legislature has to act on this. Certainly for companies like Google and some of the more progressive ones up in the Bay Area, maybe not. Maybe they're already doing all this stuff anyway. And in fact, I would kind of think they probably were. But I guess the legislature says, well, we've heard too many bad stories, about this type of company doing this and you having to use a bathroom. We don't want that. We want a clean place where people can lactate. And look, there are more and more women in the workforce, and you just got to deal with it, guys. So I think that's where this is coming from. And I think it makes a lot of sense, especially when you think about, women, they're going to work, they're going to be pregnant, they're going to have babies, and they want to come back to work because they have to start paying bills again. So, you got to let them take care of their babies.
And they have to have a place so they can have proper milk storage. This is, so Nancy, do you have anything to say on this?
I'm just thinking about companies like when I worked at the Auto Club, that it's a huge company with offices all over the place. But
Yeah.
and they sell insurance and they handle car claims and things like that. And they have tiny, tiny break rooms. And I'm just thinking back that there's, even though it's a huge company, with all the offices, as far as what I don't know what it's like now, but there would be no way that you would, they would just send you home and say, go away.
Yeah.
There's no way. You have a break room where anybody can go at any time. So there's no space for.
You need to have a separate
this.
refrigeration thing too.
Yeah,
Just saying.
there's just no way.
Well, and all right. If the employer has 50 or fewer employees, and I guess AAA probably doesn't, but it might depend on how you. Yeah, all right. Then you can ask for an exemption. And I got to tell you, though, when I saw that in the law, I'm going, how many small employers are actually going to take the time to ask for an exemption? It really might take a lawyer. I'm not sure how effective that exemption provisions are going to be, but it's there. So if you have 50 for you can get an exemption. AAA, no, it doesn't sound like it apply. So if it doesn't, well, then they're kind of stuck with this. So how are they going to deal with it? Do they have to move offices and get another room? Do they bring in, I think you could bring in a separate room. Now, and some of these requirements, it has to be clean, safe, and shielded. So let's say you brought in a trailer. That would probably work there. And as long as it's close to the workspace, that's subjective. So probably could do it. But then, yeah, you got to make sure it has electricity and the proper milk storage. I didn't say refrigeration on purpose because it does talk about the ability to use a cooler instead. So, yeah, if you got electricity, maybe it makes sense to have a refrigerator anyway, but you can use a cooler. Seating in a trailer is fine, and a place to put the pump, you should be able to do that. So I'm just going to say, I think AAA is going to have to do something. Yeah,
well, and Nancy was there, like this was a number of years ago, but when you think about now with these big companies and there's a privacy thing, that's a real, that's a privacy thing and a cleanliness and all that, like you're saying. I mean, it's kind of like, how George Costanza wanted his own bathroom on Seinfeld. It's like, here, I want my own area, So I think, women are productive, and in that way too. They're productive, but they do need those things. I mean, and women are part of society, and this is nature. This is what happens. If people want children, then you got to, help the woman. Just saying, with this kind of stuff. So I think it's a good thing. But yeah, I think for employers, I mean, less than 50 employees to get the exemption, and then if you don't know about this law, and then you have one woman in there that gets cranky because it's not there and they didn't go for the exemption, that's where the issues start, right?
Yeah, I don't know about the liability issues. I mean, the private right of action, if there's a private right of action for violating this, it might only be enforced by the labor commissioner or something else. I don't know for sure.
This is interesting too. I wanted to get into money, because that's a big deal. Is that like your biggest, is that going to be one of the biggest things people call you on, is like, I didn't get my paycheck, or, I'm not being paid the actual minimum wage? Because that minimum wage, that was one of the top stories over the last couple of years, was, what's going on with minimum wage. And now you're going into salaries. Now, like, there's minimum salaries, right?
Yeah.
Yeah,
there always were. I haven't emphasized it too much. I mean, if you read some of my website, I do a little bit, and some of the articles I've talked about it. The minimum wage story is continuing. The law was passed a few years ago, and it required in California the minimum wage to increase, essentially, except in the very beginning, $1 a year. And so we're 2 years away from employers with 26 or more employees to having to pay, to being required to pay $15 an hour. So that's where the law ends. And we're 3 years away from that happening to employers with 25 or fewer employees. So right now we're at $12 for 25 or fewer, and $13 for 20 or 26 or more, starting January 1 of 2020. And so, that's a pretty hefty minimum wage statewide.
Yeah.
Yeah, but here's the kicker with that we don't always focus on is as the minimum wage goes up, the minimum salary to qualify an employee as an exempt employee also increases because it's a formula based on the minimum salary. It's 2 times the minimum salary times the number of hours you work in a full year, 40 hours a week, 52 weeks, which is 2,080 hours. So for 25 and fewer employees, a business that has 25 or fewer employees and has an exempt salaried person, they have to pay that person almost $50,000 a year now. That's $49,920. And if it's a business that has 26 or more employees, then next year the qualifying salary for an exempt employee will be $54,080.
Wow.
Yeah,
I mean,
so that's a pretty big salary.
That's what I was looking. I mean, what if? I mean I know that they keep doing this by number of employees. It's kind of like chambers of commerce, and their dues go by number of employees. But sometimes you could have someone that just needs a 3-person business, and they're making more than everybody else. Kind of like, look at, Amazon. Anyway, but there's could be someone, I just think it should also go by the kind of business. Just saying on that. Because what happens if you've got someone they're selling like, I'm going to go back to when I was a teenager selling hot dogs and burgers on the beach.
You go, Lisa.
No, I remember I had to wear a little hat and take my little umbrella out and flip burgers.
Oh, so funny.
Yep, flipped them in the sand, all of that. But if I was there like daily and that was my job, now I'm going to be paid $54,000 a year. I mean, a month. Yeah, a year.
Wow.
See what I mean?
If you're going to be an exempt employee, but there's no way someone who's selling hot dogs is going to be exempt.
Okay.
So they're going to pay you the minimum wage.
When they figure out what minimum wage should be, do they actually look at living conditions of people? Like, do they look at the minimum wage and say that, okay, at the end of the month you should be able to pay rent, buy some food, or do they just like, oh, let's just make minimum wage this?
And it should be by region, because if you're in San Francisco, you need to make more money than if you live in San Diego.
Exactly. Well, maybe not now, but San Diego.
Well, San Francisco is a little more. Yeah, San Francisco is a little more expensive than San Diego, but San Diego is plenty expensive.
Yeah, it's
compared to the rest of the country.
It is.
Yeah.
How do they figure out how much you minimum? When I hear minimum, I think, okay, that whatever the job is, if you do it and you don't get fired, you should be able to afford rent. But it doesn't look to me like that's really true.
All right, so minimum wage where it is now, well, let's just use $12 an hour and an 8-hour day. So you're at $96 a day. So that's about $100 a day. So that's where we are right now, and it's going to increase a little bit in the next couple of years. So $100 a day, what's that going to pay for? Let's assume 20 work days in a month. So that's $2,000 a month. Are you kidding me? In San Diego, especially San Francisco, I mean,
it's not even rent.
No. So, all right. So, we can debate this all day long. Is that what minimum wage is trying to do? Is make a living wage for everyone? I don't think so. It's trying to set some type of floor. Now, a lot of people argue against it. They say, well, wait a second. If the market doesn't require that type of pay for that kind of job, now you're inflating the cost of labor, and that's hurting everyone. It's increasing prices at McDonald's. In fact, I just had lunch with one of my good clients. He has a very successful restaurant, and I was saying, I've noticed everyone's prices are going up in San Diego restaurant industry. And he goes, yeah. And I say, I'm thinking that's minimum wage. He said, yeah, it's about half minimum wage and half product costs. He said they've both gone up. And I go, yeah, I guess that makes some sense. So we all pay for it.
Exactly.
So, what do you want? You got to make a choice. You got to make a choice. You got to go, it's worth it or not. And different people have different feelings about it.
Yeah.
Yeah.
Well, I think people should be able to afford, but it's true. It's like a seesaw on this issue. I do believe
Mm-hmm.
people should be able to afford their rent and the basic things in life, and then you aspire to become more, and do more in life and get more qualified in things and all of that. But yeah, I think and San Diego, yeah, San Diego's, I think that's been on a steady climb of things, but it's a very successful city. I think San Diego is one of the coolest cities on the planet because you've got the mountains, you've got the desert, you've got the ocean, the whole area, I
Yeah,
should say,
no, it's a
the
great
county.
place. I
It's
love San
awesome.
Diego.
Yeah. And the more awesome it is, the more it's going to cost. You've got beachside real estate and, oh man, San Diego's awesome. A huge tourism economy, but also gas prices in California. Nancy and I were talking about that because California is on our next route. Next 2020, we're coming through California, and we're excited. It just, you look at the cost of it. I remember one trip we did, and I was like, oh my gosh, our bill just like, I would say went up like 5 to 6 times one year that we did our tour through California. But we went up to Washington and Oregon, and the gas prices went up and up. So that
Yeah,
that
really.
affects everybody. I think gas prices affects everybody, and that's part of it too. So that's why the products go up, and so yeah.
Oh, absolutely. Yes, everything's more expensive in California, and there are various reasons for it. I got it. I have to say, be careful about government regulation. Is that how you really want to run the economy?
Right.
But I'm not against minimum wage. I just think that if the government, if it's such a great idea, why don't you make it $100 an hour? Well,
Yeah.
That's impossible. It just wouldn't work. So, is a little bit of that same idea a good idea? That's a policy issue. Make your call. But at $12 and $13 an hour, I think it's fine.
Yeah.
Hmm.
Okay, so now what about family leave, paid family leave? I know one of the most popular articles you've done was about sick leave and vacation time. So obviously this means a big deal to our readers and to our listeners. So tell us what's changed up on that for California.
Oh, I'm sorry. I lost track of what you're saying.
I know he's up in minimum wage land. He's like, everybody just paid family leave. That's one of the things that the
Oh,
changes.
paid family leave. Okay, yeah.
No, we're done with lactation now.
Yeah, okay. I was making sure we're off the lactation, because we didn't really even spend that much time on lactation. I mean, that's a big deal. But anyway, yeah,
yes, it is.
clean, safe place with electricity. Yes, it's pretty cool.
Yeah, stored in a cool, dry place. There it is.
Oh my goodness.
I've got the traveling Wilbury stuck in my head now. Okay, sorry. Okay, paid family leave.
Yeah, all right, paid family leave. So they extended it.
Okay.
They extended it from 6 weeks to 8 weeks. It's paid family leave is funded through withholdings from paychecks. And the government holds on to it. And then if you qualify for paid family leave, for instance, if you have a sick family member, you want to bond with a baby or an adopted child, then you can apply to the state of California for the paid family leave benefit. And assuming you qualify for it, then you get checks. Now, they're not going to cover all of your salary or wages, but they'll cover some of it. And rather than for just 6 weeks, it's now for 8 weeks.
Okay. Wow. That's moving on up. That's good. 8 weeks is good. Employment arbitration. That's a big word, Ward. Like, even reading that, I'm like, oh, okay. So
yeah,
talking about arbitration agreements. Okay, I'm having a blonde moment with this. Could you explain that to me?
Yes. Well, yeah, just that word can lose people. All right, so you can agree with another party with which you have a dispute to take that dispute to arbitration rather than file it in court.
Okay.
And there's the American Arbitration Association. There's others that are similar to that. And they have rules that that operate those systems they run, and you're subject to them rather than the courts. And often they're pretty similar. But the idea behind arbitration, at least originally, was to make a streamlined process that could be less expensive. And I got to tell you, since you pay for the arbitrator, since you pay for filing, more filing than you would in court, actually, if you just pay for all sorts of stuff in these, and it's not cheaper. Now the question, to me, the only real advantage is, well, maybe you can get this done more quickly and more informally, and that's true. Usually you can do it more quickly. I was in one not too long ago that took a year and a half to get to arbitration, which is just ridiculously long. But the case was interesting and complicated. So that normally doesn't happen. Normally it is more quick, and it certainly is less formal. The rules of evidence don't apply. All sorts of other things streamline the process. Will hopefully streamline the process. Basically, what you're saying is we don't have too many rules here, but the arbitrator gets to make all the calls, and that's what when you sign an arbitration agreement, that's what you're getting, is an arbitrator basically making all the calls. There are rules, but it's just not as complicated as the systems that we've set up in court. And there's good reason, historical reasons for having it the way it is in court, but they try to cut through that a little bit with arbitration.
Wow.
So
it's like mediation.
Something.
It's kind of like going to a mediator.
Well, it's similar.
Almost,
mediator doesn't make a ruling. Mediator tries to get two parties to make an agreement, but they don't have to agree. They can just say, all right, we don't have an agreement. I don't agree with what he's saying. I'm leaving. Arbitration is different. The arbitrator decides the case. So you have to put on evidence the same way you would in court. You don't have the same rules of evidence, though, generally. And the arbitrator makes a call and issues an award that is enforceable in court. So that's the difference. So it's like a mini trial before a bench, before the judge rather than a jury. There's a lot of similarities. So that's really what arbitration's about. And then, but here's oh, go ahead. I'm sorry.
I'm sorry. I went to arbitration in South Africa. That was really interesting. Right. Yeah, because I had a Muslim employee and a Jewish employee.
Right, I remember that, and they had a
Sounds
war.
like a joke, but it isn't. And the Jewish employee got really upset, and she said that the break room, which was my kitchen in my home, and the office was actually down the driveway in what used to be a doctor's office. So my house was at the top of the hill and the office was at the bottom.
Of course it was at the top of the hill.
Exactly. And so when people wanted, if they brought food that they wanted to keep cold, I let them put it in my fridge. So the Muslim and the Jewish people got upset with each other over something somebody put in the refrigerator. And so the Jewish lady took me to arbitration. And I won because the arbitrator, and it was funny because he just came to the house. It was weird. He came out.
It's formal.
Yeah, and so he came to the house, and he said, well, you don't have to let people in your kitchen.
Yeah.
They can take a break outside. They can take a break in the sitting room in the office. They can take a break in their car or whatever they want to do. I don't have to give you a place to store your food. So I won, and then I fired her, and then that was when things went like, whoa.
So what? It's a good thing.
She was a troublemaker. So no, and I asked him, can I fire her? And he goes, yeah, let me help you. That was really fun.
Wow.
Wow, Nancy. I know. I'm like, it's a good thing you didn't have to, you set up a lactation station in your house. Could you imagine?
I know.
That's really what it should be called, lactation station.
But there was fees. There were fees, and she had to pay all the fees. So she lost. Does that happen here? Like any legal fees are paid by the side that lost?
Generally, the only way you can get that done is, at least in California, is through a statute that allows for legal fees. So, yeah, you can get it done that way in arbitration. In fact, that ended up happening for us in this arbitration I just mentioned. Or an agreement. So if you have an agreement that says the winner in the dispute is entitled to attorney's fees as costs or whatever, then yes, you can that way. So it's possible, but it's not required. Now, the laws the new laws on arbitration that I wrote about, one of them would require the employer, if they don't do things right, to pay attorney's fees, even if you don't have an agreement. And so again, that's a statute that says you get attorney's fees under these circumstances. So it would fall into the first category of a law that's on the books that allows for attorney's fees. Yeah, and there really are, I think, two major changes to arbitration in California. And the one is, and this is the one that's kind of rocked the world, is they're prohibiting arbitration agreements between employer-employee, or required arbitration agreements between employer and employee. So if the employer says, you've got to sign this or you can't work here, they're saying, no, you can't do that. You can't make them do it. Now, the problem with that is the AAA, well, not AAA, excuse me, the American Arbitration Act. Shoot. I'm not remembering the name of the act, but it's the Federal Arbitration Act. Mm-hmm. And it has given broad rights. The Supreme Court of the United States has said, hey, look, once you sign one of these agreements, it's just enforceable, and don't try to mess with it. And California has done various things over the years to try to mess with that. And this is the latest salvo. And so it looks to me, I'm going to guess that it's going to get overturned and be called unconstitutional at some point.
Wow.
But we'll see.
Wow, this is going to be another one of those through 2020 to watch. Man, it's interesting. It's interesting. Yeah.
Yeah, wow. The reason why they want to do that is because those arbitration agreements can limit the rights pretty drastically.
Yeah,
it depends what you call a right. It's like you can have a clause in an arbitration agreement that says you cannot bring a class action or a mass action.
That's what I was going to say. It's like you can come work here and someone's going to sexually harass you, but you're not allowed. But you sign this paper, and basically it's like signing your rights away. Like that's how it reads to me.
Well, to some degree, first of all, they're forcing you to go to arbitration rather than the court system, and that can be really expensive, prohibitively expensive. Usually, those agreements say, "Well, no, the employer will pay for most of it or all of it or whatever." So usually they're okay, but that can bring up problems even under the law now. But then the second law addressed that again and said, "No, the employer really has to pay for this stuff, at least initial costs, and maybe there's some other costs that the employee can take care of later. But if the employer refuses to do that, then they lose the right to arbitration." I think that one may survive, because all they're saying is, well, the employer's got some duties here and they need to pay. And so that's not preventing the agreement from going forward. It's just saying, hey, we just want a little more fairness here. So I'm thinking that may get challenged, but I'm thinking that it certainly has a much better chance of surviving a constitutionality challenge than the other law that prevents arbitration agreements for employment. Now, but that was the whole thing. The reason why they did that was California's had a hard time with the Supreme Court saying, yes, arbitration agreements can require that you give up the right to class actions. And so many employers have had these arbitration agreements that include a class action waiver. And so California is saying, no, we just don't think that this has any place in the employment arena. And again, I think that's probably unconstitutional, but we'll see. We'll see.
Wow. So everyone, keep up with Ward. Go to bestemploymentattorneysandiego.com and keep up with him for all of this, as he's changed. And of course, we'll cover it on the shows and, radio shows and also editorial. But a lot of stuff. I have one last question here that popped into my head. And it kind of was the arbitration thing that kind of made me think about, remember they made that law that you couldn't have the TV crews inside of, was it the O.J. Simpson trial that they started it where you couldn't watch the trial anymore? Like there was I don't know if it was O.J. or maybe it was Bill Cosby. Who wants to watch that?
Yeah.
It was something where you couldn't watch that, right? And I was just thinking, okay, so what happens when something goes down, like this Survivor thing with the sexual harassment on the show, right? She, because she was part of that show, ends up on TV dealing with it. Whereas you don't, sometimes you want to keep stuff like that. That's personal. That's a personal thing. Are there protections like for something going on, like even if you were as an employee accused of theft and it wasn't you, maybe it was somebody else, that it doesn't get broadcast to the media somewhere? Is there any kind of protection when it comes to things like that?
Well, the basic protection is defamation. So if it's
Okay.
not a true statement, and it's not a statement of opinion, so often you can say, well, that person's dumb, and it's just a statement of opinion. So, whether you can win on that or not depends on whether it's opinion or fact, a factual statement. But if it's false, if it's a false factual statement, then you can always sue on that. There's almost no limitation. But then in employment arena, there's also discrimination laws that allow for disclosure of at least harassment and discrimination facts. So you can't wait. That was really common until these laws were passed last year, to have a waiver in a settlement agreement that says no one can disclose these facts, essentially. But now the law says, no, you can't do that anymore. So, and if it's tried to be done, there are potential ramifications.
But in this case, where millions of people were watching the show and saw at least one incident, it just seems maybe editing that. Could you? If I was the TV crew or in charge, I probably would have edited that out.
Well, it depends on the girl, maybe.
Because it's
and then there's potential privacy too. That's no, I hear you.
But but
that kind of depends on what she wants. In an employment situation, you can elect as the employee who has been harassed to have that public or not.
Okay.
So
it's survivors. I mean, like I say, it's odd because they're not really employees. They're people trying to win money in a game, and they show scenes of them all sleeping together, not sexually sleeping together, but
some do.
They would show that, but they're strangers and they're sleeping next to each other in the sand with a hut over, like a thatch roof hut over their head thingy, and that they built themselves. So everybody's all kind of cozied up.
They've gone
cavemen. It's an odd situation.
Yeah.
Because they don't really know each other, but they're sleeping next to each other, and the women are really just wearing bikinis all the time. So, and the men are just wearing swimming trunks. So it's kind of like
it's waiting for things to happen.
Yeah.
Wow. I guess I'm gonna have to start watching. Holy smokes.
He's like, wait.
You need to watch one episode so you see what we mean. Because sometimes I look and I'm like, the one lady, she'll be asleep and the guy will lie down next to her, and then they show a scene of like, his arm just somehow went
Nancy,
over her shoulders.
This is a family radio show.
I'm being good. And, all of a sudden the next scene they show his arm is like over her shoulders, and she's kind of like stuck there. And I'm thinking, well, if the camera crew is filming this.
Well, they said that Survivor said, Jeff, the guy that the TV show host, apologized on TV to this girl and said we should have listened from the beginning and taken action right there and then.
Absolutely.
And so their company policies are changing over this. And Nancy and I are watching this going, cool, we're interviewing War tomorrow. We gotta bring this up. Because it was like, but they said that they added, I don't know, as a company, they're changing policies and all of that kind of stuff. So I thought that was pretty interesting for them to even be that open. You know what I mean? And maybe that's about dealing with it head on, because when you look at Dirt getting, like, she could go around and start trashing the company for not doing anything at the end of the day. And that's what happens in these Me Too movement cases.
Yeah.
It's like, you might as well deal with it head on and make it into something a little bit positive. And I think that's probably what happened. But it's interesting when it's a big company like that, because it was sexual harassment, and it did go into employment law because the guys started getting all touchy with one of the employees.
One of their staff.
Uh-huh.
Yeah.
So,
no, that could invoke that. You're right.
Yeah, so it's interesting. Well, listen, everybody, 2020's got some new laws, so check it out. Again, Ward's article's up on blendradioandtv.com, and you'll also see the article in the upcoming February-March issue of Big Blend Radio and TV magazine. The best thing, again, is to go to bestemploymentattorneysandiego.com. Ward is on Facebook and Twitter. And, of course, keep up with us at Big Blend Radio. We're at bigblendradio.com. We air shows Monday, Wednesday, Fridays, and Sundays, and all the different outlets are listed up on the website. And of course, we love to play music. And Ward, today your song is called Work. It's one of my favorite songs. It's from the Joiners Band, and this is from their first album, Olives and Oil. And we actually, it's like the song should be called I Don't Want to Go to Work. And after all of this, maybe we don't. So here it is. Work. Thanks so much, Ward.
Thanks.
You're welcome.
I don't want to go to work, working for a man who just treats me like a jerk, and he doesn't even know my name. Next time he asks me, I'll swear it's pudding take. But I don't want to go to jail. It stinks what I breathe in, and there's no room to exhale. Won't somebody go my bail? 'Cause I don't want to go to jail. Now please release me from this grip. I never signed up for this. Now please release me from this hole. Let me grow old. Let me grow old. And I don't want to go to war. And I ain't much for shooting, that ain't what I'm aiming for. And all my soldier friends are poor, fighting rich men's war. And I don't want to go outside. It's so scary on TV, and television never lies. Everything it sells I buy. And I don't want to go outside. Now please release me from this grip. I'd never signed up for this. Now please release me from this hole. Let me grow old. Let me grow old. The bells are ringing noon where we are. Put your hammers down. The church is just on the hill.